Will the defense call their next witness?
The defense calls the defendant, Carson Connors, to the stand.
Mr. Connors, will you raise your right hand? Is the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir.
Hi, Carson. How are you today?
Doing good, thank you. How are you?
I'm good. All right. Can you state your name and spell it for the record?
Yes, my name is Carson Connors, Carson, Conners.
Thank you. And where do you reside?
534 South Percy Street, Big Town, Washington.
And where do you go to school?
Big Town High School.
And what grade are you in?
11th grade.
And do you have any trouble getting good grades at schools? Sorry.
Yes, I actually get C's and D's.
And why is that?
Well, I work as a cashier at a Dollar World to bring money for my family. And because of that, I do not study as much as I should. My family life is not a much of write home about. So I hang with my friends after school and on the weekends to avoid going home. I also don't get help in school. The teachers are supposed to teach us and help us learn, but I do not feel like I get any help from teachers.
Have you ever explained your situation to your teachers before?
No.
And why not?
Because my teachers never asked. They never seem to care.
Is Miss Smith one of your teachers?
Yes, she's my English teacher.
And do you think Miss Smith is a lazy teacher because she doesn't interact and help you with your work?
Objection, Your Honor. Leading question.
Sustained.
I'll rephrase. What is your opinion of Miss Smith as a teacher?
Well, I think she's a lazy teacher. She only really interacts with certain students who do well in class.
And does she engage with you or help you with your work?
No, she doesn't. This is one of the reasons why I have bad grades in her class.
And have you taken the standardized tests before?
Yes, we take them every year, and we go and we do. If we do good enough, we get extra points in class.
And have you ever bullied any other student before?
No, never.
So what happened on the day you got arrested?
Well, my lunch period is at 11:30. I finished my lunch and was on my way to my next year, which was to begin at 12:15 p.m. I saw students from my neighborhood at the community center and recognized their face. So I went up to the student and
Objection, Your Honor. This is a leading question or a narrative question. Sorry.
It is narrative. Counsel, proceed to ask direct questions, please.
Yes, Your Honor. How about we just break that up a little bit, Carson? So let's just go on. Then what happened after you recognized that student?
As soon as I did that, Ms. Smith came to me and yelled at me to stop, and to the assistant principal. Well, she yelled at me to stop, and to the assistant principal's office. She took me to the assistant principal's office. I didn't think I was doing anything wrong, and I did not understand why I would have to go to the assistant principal's office. I was also getting close to the start of my next class, so I refused to go. I didn't want to miss my class.
So did you in any way act violently or threatening toward the student that you had recognized?
No, I just patted them on the back because I recognized them.
And you said this occurred right around 12:15 when your class was starting, right?
Yes. Ms. Smith grabbed my arm and tried to pull me to the office. I pulled away just like anyone will do if they were being grabbed unexpectedly. And I told her to take her hands off me, and she couldn't tell me what to do. So I called her an idiot. I didn't mean it though. It was just a surprise outburst. And I look back, I regret saying that to the teacher.
So did you act any way threateningly or violently when you said those things to Miss Smith?
No, I was just surprised when she grabbed me. I also just didn't want to miss my class, and I didn't do anything wrong.
Did you intend to cause anyone inconvenience or annoyance or alarm when you said those things?
No.
And And did you touch Miss Smith in any way?
She just grabbed me and pulled away.
And so why did the officers arrest you?
Well, Miss Smith told them that I was assaulting a student and causing disturbance.
Objection, Your Honor. This is hearsay.
Can I respond?
Yes, please.
It is a hearsay exception under the present state impression exception. The witness, Carson, is describing the event as they perceived it to have happened.
Objection overruled. He can answer.
So Ms. Smith said that you were causing a disturbance. Is that correct?
Yes.
Okay. Did the officers read you your rights when they arrested you?
Not that I remember. It was just me. They just put me in handcuffs and hold me off.
And did they inform your parents or the vice principal?
No, I wasn't able to call my parents until after an hour after we got to the station.
And how do you feel about this whole ordeal?
Well, I feel upset. I feel that I might have been unjustly targeted because Miss Smith made this crime up. I could lose my job because of this.
Do you know why Miss Smith would make something up like this?
I think she must have made it up in order to get me out of school during the testing so that my historically low scores will not affect her overall class scores and she will get to keep her job.
So what happened to that student that you patted on the back?
Nothing. Miss Smith never talked to the student. No one did.
And are you trying to hide that student's identity?
No, I wish we can find them. They will clear this whole thing up.
Would you consider yourself a student who tries in school?
I think so. I have difficulty understanding certain subjects, but I try hard to learn them. I don't slack off, and I'm not involved in any gangs. I really do want to do well in school, but I'm not ashamed to admit that I need help in certain subjects.
Thank you, Carson, for sharing your story here today.
Yeah.
Prosecution, ready for cross-examination.
Yes, Your Honor. Hi, Carson. My name is Stephanie Grover, and I am the prosecution in this case. How are you today?
Doing good, thank you. How are you?
Good. You said that you believe you have bad grades in Miss Smith's class because she doesn't engage or help you with your work. You have not explained your situation or sought her help, correct?
Mm-hmm.
Okay. Is that a yes?
Yes.
Okay, thank you. To go to the incident in question in this case, you said that basically as soon as you patted the student on the shoulder in the hallway, Miss Smith saw you and came right up to you and yelled at you to go to the assistant principal's office. Is that right?
Mm-hmm.
So
yes.
Those events happened in pretty close conjunction with each other?
Yeah.
Okay. So if those two events happened pretty closely in time with each other, wouldn't the other student have still been either still standing in the vicinity or at least within earshot and have heard what Miss Smith was saying to you?
Yeah.
Okay, and if you don't know for sure, is that a fair speculation? I mean, would you assume that a student could move completely out of earshot within the matter of a couple seconds?
Objection, it is speculation. He has
Sustained.
Okay. So the other student did not come to your defense, right? This other student fled the scene?
Yeah.
Okay. You claim Miss Smith grabbed you when she came up after she saw you pat the other student. Is that correct?
Mm-hmm.
Okay. And you intentionally yelled at her and called her an idiot, right?
Yes, but I didn't mean it.
Okay. So as far as you know, there are other students in your class that don't excel in school or on tests, right? You're not the only student who, struggles or may have a hard time with standardized testing, right?
Yeah.
And of all those students who also struggle, to your knowledge, they were not all kicked out the day of the test. Is that right?
Yeah.
Okay. You don't have evidence necessarily for your testimony that Miss Smith made this whole scheme up as an elaborate plot to get you out of school the day of the test, right? This is just your assumption.
Yeah.
Okay. No further questions, Your Honor.
Any redirect?
Yes, Your Honor. Carson, did Miss Smith ever offer to help you more and help get your grades up?
Not really. She only, like I said, she only cared about the students that were doing good in class.
And was it intentional when you yelled at Miss Smith, or was it more like a surprise outburst?
It was a surprise outburst.
And was there any other reason that you could think of that Miss Smith would come after you if you weren't doing anything wrong, other than that she might have been making this up, in your opinion?
Not that I can think of right now.
Okay, thank you, Carson.
Any limited recross?
Briefly, Your Honor. Carson, is it Miss Smith's job to know the out of school life of every single one of her students?
I would say no.
And isn't it incumbent upon the student who is struggling to seek out help that they need in school?
Yeah.
Okay, nothing further, Your Honor.
Then this witness is excused. You may step down, Mr. Connors. Thank you.
Thank you.
We're back from recess. Defense, call your next witness.
The defense calls Billy Joe Stapleton to the stand.
Ms. Stapleton, raise your right hand. Is your testimony that you're about to give the truth, the whole truth, and nothing but the truth, so help you God?
Good morning, Ms. Stapleton. How are you? I think are you muted? I can't hear you. Oh, no.
Is that better?
There we go. Thank you.
Sorry about that.
Can you please state and spell your name for the record?
Billie Joe Stapleton, Billie Jo Stapleton.
Thank you, Ms. Stapleton. Where do you reside?
I reside in Big Town, Washington.
And what is your education?
I have had an extensive education after high school. I went to MIT and received a Bachelor of Science in Engineering. And then later I went on to get a master's degree in arts and education from Stanford University. And I also have a certificate for a secondary math teacher.
And what experience is relevant for the jury today?
I've been a math teacher at Big Town High School for the past 35 years, and I'm now retired.
And do you have a good teaching record?
I've had a very good teaching record. I have earned some senior status in the high school, and I have good reviews, and my students are doing well.
And why did you end up retiring after 35 years?
The reasons. The one that actually initiated it was that Vice Principal Crosby, has made it known that I was going to be teaching. I would be not teaching the calculus and the AP classes that I've been teaching, and I would be dropped down to an intermediate class of geometry for the next year. And I did not want to have that professionally, and I felt like it was not going to be using the skills and experience I had, as well as the direction of the school's philosophy was changing, and I could not support it as it did not meet with my personal values and goals in teaching.
And as a person with decades of experience as an educator, do you think Assistant Principal Crosby is a good educator?
Objection, Your Honor. Relevance.
I'm going to overrule that at this point.
I met her about 10 years ago, and I had my doubts in my first meeting. She was very much a micromanager, very into statistics and figures. She did not really have a caring attitude towards the growth and opportunity for students. She also did not, it was no mystery that she was not comfortable, nor did she want to be in the classroom. So I felt that she was not the educator that I had hoped to have in the leadership position at our school.
And how did Dr. Crosby treat at-risk students, in your opinion?
As for at-risk students provided, it seemed to provide to her negative effect on the outcome of the school's standing. So there was I felt like her attitudes and actions discriminated against at-risk students very often.
And what do you think of the school to prison pipeline theory?
This is very, very concerning. A very, very concerning direction that the school has taken to me. It seems like that program is becoming very prevalent in our school, and it's a program that's not focusing on the needs of the students, but actually discriminating against those that are at risk and in favor of helping the school to look better.
And so what kind of students are being subjected to this school to prison pipeline theory that you've observed?
Oh, it's the at-risk students. It's those who have low grades, and that's what we're talking about as at-risk students. Those with low grades, and it causes them to be removed from the school through a suspension process, and that thus they miss the test. So it's these at-risk students who have low grades, generally speaking.
And so what happens once they're suspended from school?
Well, they miss the assessment tests that are the statewide assessment tests, and therefore their lower scores are not, that they could potentially show would not be added to the school's total score. And because they miss that test, when they get back to school, then they take another kind of test that does not apply to that statewide testing score. And it's one that doesn't really count other than their own records.
And how do you know that Dr. Crosby was a big supporter of this school to prison pipeline?
Well, I heard him talking about it one day, and it was not just talking about it, it was the general direction that she was moving the school in.
And do you know the teacher, Lauren Smith?
Yes, she's an English teacher, and I've seen her and Officer Jones eating lunch together in the faculty lounge several times.
And have you ever overheard them whisper anything to each other during these lunches?
Actually, I did hear them whisper about their intent to get the students who usually score
Objection, Your
poorly.
Honor. This is hearsay.
Sustained.
I'd like to raise an argument in favor of having this testimony heard.
Proceed.
This is should be admitted, even if it is hearsay, under the hearsay exception state of mind. This will fall within the state of mind exception, and it is admissible as proof of Lauren Smith's and Officer Jones' intent to get certain students suspended before the tests.
May I respond, Your Honor?
Yes.
The statement goes towards the truth of whether Lauren Smith and Bobby Jones said those things that the witness was proceeding to state that they had said.
I'm going to sustain the objection.
Thank you, Your Honor.
In your opinion, what kind of student is Carson Connors?
Carson is an at-risk student, definitely.
And so he would be likely to be subjected to this school to prison pipeline theory?
Yes, very much so. So without taking the time to figure out how we could help him or improve his scores, he was, I believe that he was, the situation that he was used to not benefit him, but benefit the school scores.
And what is your recollection of the incident involving Carson and Lauren Smith?
Carson was arrested, and as a result, he missed the assessment exam in Lauren Smith's class. And when he returned afterward and scored in the lowest quarter of the makeup test, he did take the test, he scored low, but that test doesn't count for the district or state scoring purposes.
And do you know of any other students who missed the test?
Yes, in fact, several other students who have poor academic records were out of school through suspension and were not able to take that specific English test until later.
And so did this incident contribute into why you ended up retiring at all?
It kind of was the thing that broke the camel's back. I had misgivings about Crosby for years, and the whole incident with Lauren Smith just tipped me over the top. Crosby had been trying to get rid of me for years, and I couldn't work at a school where the school to principal pipeline was so prevalent. It also didn't coincide with the personal values I have for teaching. It's not what teaching is all about. It's not helping the students to be all they can be and become better and contributing citizens to our democracy.
Thank you, Ms. Stapleton.
Cross-examination.
Thank you, Your Honor. Hi, Ms. Stapleton. My name is Stephanie Grover, and I am the prosecutor on this case. How are you today? All right. You would say that bullying interferes with an educational environment as someone who has taught for decades, right? Can you answer audibly, please, for the record?
Sorry about that. Yes, I would.
No worries. Thank you. Doesn't having a zero tolerance for bullying policy within a school promote a safe and productive learning environment, in your opinion?
A zero bullying tolerance can, yes, but it's not, yes, it can.
Thank you. You testified, Assistant Principal Dr. Crosby is in charge of student discipline, correct? Or is that your understanding if you didn't testify to that?
As assistant principal, she does have a lead role in discipline, yes.
Thank you. And there are approximately 2,000 students in Big Town High School.
I think so, yes.
So Dr. Crosby is in charge basically of discipline for all of those approximately 2,000 students, right?
In part, yes.
Okay. That seems like a pretty big job for one person, wouldn't you say?
Not if it's a team. For one person, it would be, but not if it's a team effort and a shared responsibility.
But you also just testified that Dr. Crosby is in charge of that team. Is that correct?
In charge of the team, yes.
Okay, thank you. So to me, it seems that if he's in charge of a team, is in charge of a team that's responsible for the discipline, among other things, of over 2,000 students, that doesn't leave her a lot of time to deal with students who refuse to cooperate with the school discipline system, does it?
No. When you say the school's discipline system, in the pipeline system.
Objection, Your Honor. This calls for a yes or no answer.
Sorry.
The witness is directed to answer the question, yes or no.
Could you repeat the question, please?
Yeah, certainly. So as the person in charge of the team that disciplines approximately 2,000 students, it seems to me that that doesn't leave him a lot of time to deal with students who refuse to cooperate with the school discipline system. Would you agree?
Yes.
Thank you. All right, you testified, you have overheard Dr. Crosby or somehow got an impression that she is a supporter of the school to prison pipeline and getting students out of school and not dealing with students in the school disciplinary system. But you really only have what you've heard, right? You don't have other proof of this, do you? That he is a supporter of this and wants to get students out of school merely for the purpose of getting them out?
Could you just say the question again, please?
Yeah. I'll try to rephrase it so it makes more sense. You testified that Dr. Crosby, in your impression, is a supporter of the school to prison pipeline and getting kids out of school just for the purposes of getting them out. but you basically testified that you've just heard him say these things, correct? You don't have any other proof of this?
I've heard him say that, yes.
Okay, thank you. And there are a variety of reasons a student can get suspended, correct? Such as end of year restlessness leading to insubordination and acting out, bullying, etc. Is that correct?
Yes, but yes, it is correct.
Okay, thank you. That's all I have.
Redirect.
Yes, Your Honor. Ms. Stapleton, were you ever aware that Carson ever bullied anyone?
I was not aware of that.
Ms. Stapleton, I can't hear you. Can you speak directly into your microphone?
Could you ask the question once more, please?
Were you ever aware that Carson bullied anyone?
No, I was not.
And in your opinion, how should bullying be addressed at a school, like through the school disciplinary process or through the criminal justice system?
I think it should be addressed if there's no illegal action taken as far as against the law. It should be handled through the school and with the parents.
Even with the zero tolerance bullying policy?
Yes, I do.
And in your experience of 35 years, did you not only overhear but also experience Dr. Crosby discriminating against at-risk students?
Yes, that is true.
Thank you, Ms. Stapleton.
Limited recross.
No, thank you, Your Honor.
Then this witness will be excused. Thank you, Ms. Stapleton, for your testimony. Court will be at recess. We'll reconvene with the next witness. Court is at recess. Is the defense ready to call their next witness?
Yes, Your Honor.
Proceed.
The defense calls Dr. Avery Johnson to the stand.
Dr. Johnson, will you raise your right hand? Is the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God?
It is.
Thank you, sir. Proceed.
Dr. Avery, can you please state and spell your name for the record?
Avery Johnson, Avery Johnson.
Thank you. And where do you reside?
Big Town, Washington.
And what is your education and experience?
I have a bachelor's degree from the University of Alberta in 1987. I've got a master's degree in educational administration from San Diego State in 2001. And I completed a doctorate in educational leadership from the University of Washington in 2018. I served as a principal for 20 years in public school districts. 15 years I spent developing an alternate storefront school that served the needs of students that required a more flexible programming than traditional schools offer. So that could have been student athletes, teen mothers, students under suspension. Without this flexible learning option, many of these students were at risk of dropping out of school altogether.
And so oh, sorry, go ahead.
I was just going to say that since I've completed my doctorate, I still teach at University of Washington because I enjoy interacting with the up and coming educators and helping them see the challenges of supporting all their students, including the at-risk students.
Thank you, Dr. Avery, or Dr. Johnson. What school policy or policies have been the focus of your work lately?
I've been focused on the zero tolerance policy and how it's created a phenomenon that we've come to know as the school to prison pipeline.
And what do these mean?
Well, many people think that schools are too lax in creating a disciplined environment for learning. So to improve classroom behavior, many schools have adopted a zero tolerance policy for violating the school's codes of conduct. So this means that minor infractions in which students get involved with bad behavior, violations of the school code of conduct, they often escalate to being prosecuted in the criminal system. So this usually happens when the principal handles the classroom situations and then calls in the police for unruly students.
And so what happens to the students in this scenario?
Well, the student then, for some classroom behavior, goes into the custody of the police, is taken into the police station and criminally charged.
And what happened at the schools before these policies were implemented?
Oh, before zero tolerance policies, it was rare for a principal to call the police. I mean, he would have had to pick up the phone and phone the police station. It happened, but not very often. But now school administrators, they have a policeman right there in the school.
And have you conducted any studies at high schools or schools involving these policies that you've just shared with us?
I have, yes.
And what schools or school have you been conducting these studies at?
Well, all around the area, including Big Town High School.
And what factors show that schools have adopted a school to prison policy?
Well, if they have a school resource officer, that's a big component of the school to prison pipeline.
And what kind of minor infractions or incidents are you seeing being put into this school to prison pipeline?
Oh, it could be anything that violates the school's code of conduct. It could be bullying or suspected bullying. It could be talking out of turn, creating some kind of a disruption in the class or in the school in general.
Mm-hmm. And what's interesting about Big Town High School specifically?
Well, they're part of a standardized assessment program. So they give standardized assessment tests every year. And these tests, they're really assessing teacher performance by looking at how the overall class performance does. So they try to get their students to do their best work. Individual students can use these tests on their college admissions applications, but it's a standardized test to see how well the teachers are teaching.
And do you agree with this testing personally?
No, I don't. I think that the schools implement testing so that they can claim that they're doing a good job. But what really happens is the tests incentivize the teachers to find ways to minimize the impact of low achieving students. And sometimes that's by suspending them so that they can't be at the school when they have to write the tests.
And have you found that the zero tolerance policy is consistently applied to students?
No, it isn't. I found that high achieving students are rarely subjected to the criminal system. They have much more to lose, and they
Objection, Your Honor. Foundation for this opinion, how does he know this information?
May I
Counsel?
respond?
Yes, please.
Dr. Johnson conducted a study through Big Town Civil Liberties Society that revealed this information. It was in his affidavit.
Objection overruled. He may answer.
So the high achieving students have more to lose and they're more remorseful. Low achieving students, they're often frustrated and they feel like they don't have anything to lose. And they often don't appreciate what's going to happen when the school principal is not disciplining them, but the court system is disciplining them.
And did your study show that there was a spike in suspensions just prior to the assessment tests?
Yes, it did.
And did this correlation appear at Big Town High School?
It did.
And what kind of students were usually suspended during the time before standardized tests?
Nearly 100% of them were in the lower performing quartiles of the class. Basically, they were at-risk students.
And what was the result of the suspension?
Well, the result was that they were not in school on the day that the test was written.
Did you find that the number of students not sitting for the test was increasing or decreasing?
It has increased year after year.
And did the increase in suspension, I'm sorry, I lost my place, 1 second. Okay. How did the zero tolerance and suspension policy link to the school to prison pipeline phenomenon?
Well, once a student has been handed over to a police officer, they're criminally charged. The school then places a student who's been charged criminally on an interim suspension until they've had their hearing. So with that suspension in place, if the timing's right, they'll miss the test.
And how does the school get police officers at the school to enforce this zero tolerance policy?
Well, they pay the police officers to be there. The schools have hired police officers.
And have you ever testified against Officer Bobby Jones before?
Yes, in a case involving excessive force used against a student with disabilities. It was dismissed in favor of the city because the notice of claim was not filed in a timely manner.
And does this previous testimony in any way affect your ability to tell the truth here today?
No, it doesn't. I'm here to tell the truth of my studies. My opinions are based on my education and my experience.
And in your professional opinion, Dr. Johnson, why was Carson suspended?
I have no doubt that Carson was suspended because he was an academically challenged student. His teacher was under pressure to get the students to do well on the test. And if they couldn't do well, she got them eliminated from the test writing day.
Thank you, Dr. Johnson.
Cross-examination.
Yes, Your Honor. 1 second. Hi, Dr. Johnson. My name is Stephanie Grover, and I am the prosecution in this case. How are you today?
I'm doing good.
Good. So you just testified that, in your opinion, Carson Connor's teacher was under pressure to get him eliminated from school the day of the test so he wouldn't affect her overall test scores. To your knowledge, Miss Smith had no power over which days he was actually suspended. Is that right?
Well, no, she wouldn't be able to pick a particular day, but you can
I'm sorry.
generally.
Can the prosecution repeat their question? I didn't quite catch that.
Yeah.
You.
Miss Smith had no power over which days specifically Carson was suspended. Is that right?
Yeah, she did not pick the day, but she would know that he'd be out of school for a week.
Okay. Did your study that you testified to look at any correlations between the school to prison pipeline in larger versus smaller schools?
We didn't account for the size of the school, but it is pretty common for the large schools to have the school resource officers. The small schools can't afford them as often.
Okay. And in your professional opinion, wouldn't you believe that, or wouldn't you say that the larger schools need those school resource officers as extra support to deal with their larger number of students?
Well, they didn't always have, I would say no, because these schools didn't always have school resource officers there 10, 15 years ago.
But you've testified that the school to prison pipeline has significantly increased in recent years. So couldn't that be an indicator for the schools that they need more in-house, I guess, help to deal with problem students?
The increase in the school to prison pipeline has been in a direct correlation with the increase of the number of school resource officers in schools.
Okay. Besides the school resource officers who target the problem students and take them to, I guess, the higher level of disciplinarians, such as the assistant principal at Big Town High School, wouldn't you say that those larger schools have fewer resources as far as that higher level of disciplinarian than smaller schools to deal with these problem students in-house?
The way school districts work is they allocate administrators, school principals, assistant principals based on the size of the school. So a larger school should have more of an administrative staff. They should have an assistant principal that's totally dedicated to discipline.
Okay, and here we have a fairly large school of 2,000 students and one assistant principal. Is that right?
That is correct.
Okay. Did your study, one second. You testified that the students that are kind of funneled into the school to prison pipeline are those who violate school policies, those who bully, etc. Is that right?
Yes.
Okay. Did your study look at any correlations between those students who cause problems and students that are at risk academically?
Yes, there's a higher incidence of bad behavior among students in the lower achieving percentiles.
Okay, so you would say there's a correlation?
Yes.
Okay, but correlation does not equal causation. Do you agree with that?
Correct.
Okay. The standardized assessment that is at issue here is given at the end of the year. Is that right?
Yes, close to the end of the year.
Okay.
Mhm.
And your study, just to reiterate, looked at correlations between a spike in the year-end or school suspensions towards the end of the year in conjunction with the standardized assessment, right?
Yes.
Okay. There are a number of reasons a student could get suspended, right? Just, I mean, outside of your professional opinion, just as common sense, you would say that there are a number of reasons, correct?
Yes.
Okay. And some of those reasons could be due to students becoming more restless with the end of the year approaching and nicer weather and whatnot. Isn't that right?
Well, yes, that could be, but the high achieving students who get into trouble when they're feeling restless, somehow they don't, they get sent down to the principal's office. It's the low achieving ones that get sent with the student resource officer down to the police station.
So you're saying that your study specifically delineated between high achieving and low achieving students?
We didn't specifically delineate between high achieving and low achieving. We were just looking at the number of students that go to see the principal versus the number of students that go down to the police station.
Okay. Okay. So basically your study looked at correlations but did not look at causation, correct?
Well, that is correct, but it's because of student privacy in research that we can't ask for names, so we can't match up the names of the students that went to the principal's office.
Objection, Your Honor. This question asks for a yes or no answer.
The witness will answer yes or no.
Can you
Would you
repeat the
like me?
question?
Yes. Your study looked at correlations and not causations, correct?
Correct.
Okay. No further questions, Your Honor.
Redirect, counsel.
Yes, Your Honor. Dr. Johnson, in your opinion, did Ms. Smith know of the day the standardized test would be?
Yes, she would have known which day the test was going to be given.
And that was in advance of well in advance of when the test was given?
That would have been planned months in advance.
And could the increase in the student resource officers contribute to the increase in the school to prison pipeline, in your opinion?
Yes, absolutely.
Do you think schools should still utilize the school disciplinary process instead of resorting to the criminal system for minor infractions?
Yes, I think that minor infractions should be dealt with at the school level and not at the police station.
Even if the school is a large school?
Even if it's a large school.
And in your studies, were you necessarily looking at the reason for the suspensions or the fact that the suspensions occurred during the testing date?
We were looking at the occurrence of suspensions.
Do you think nicer weather should be an excuse for the school to utilize the criminal process?
No.
Thank you, Dr. Johnson. That's all I have.
Limited recross.
Yes, Your Honor. To reiterate, Dr. Johnson, even though Ms. Smith knew the date the test was going to be, however long in advance, she had absolutely no power over which days Carson was actually suspended. Isn't that right?
Objection, asked and answered.
May I respond?
Yes.
I'm simply clarifying due to defense counsel's redirect.
I'll allow him to answer.
Can you repeat the question?
Yeah. Just to reiterate, even though Ms. Smith knew in advance of the dates of the standardized tests, she had no power over when Carson was suspended. Isn't that right?
That is correct.
Okay, no further questions.
No further questions? Dr. Johnson, thank you for your testimony. You are excused at this time. Does the defense have any further witnesses?
No, Your Honor.
And the defense rests at this time?
Yes, Your Honor, the defense rests.
Then we are ready for closing arguments. Ms. Grover,
Thank you, Your
you
Honor.
are first up.
Thank you. Ladies and gentlemen of the jury, based on the evidence you've heard in this case, it's clear that Carson Connors is guilty beyond a reasonable doubt of disorderly conduct in violation of Washington Penal Law, Section 240.20. Remember, the elements the prosecution was tasked with proving include 1, that Carson Connors engaged in fighting or violent, tumultuous, or threatening behavior. 2, in a public place. And 3, with intent to cause public inconvenience, annoyance, or alarm. You heard from English teacher Lauren Smith that not only did she see Carson push a student down a school hallway, he also acted belligerently towards her. Bobby Jones, school resource officer, testified he also saw Carson push a student and act belligerently towards him. Thus, we have satisfied the first element of the offense, engaging in fighting or violent, tumultuous, or threatening behavior. The witnesses testified to, and we can all agree, a high school is a public place, so element 2 is satisfied. Ms. Smith testified Carson's actions caused her to be annoyed, and based on his actions, he intended to make her feel this way. Thus, element 3 is also satisfied. The defense tried to paint a picture of bias to you, that the prosecution's witnesses were trying to satisfy ulterior motives, and Carson Connors was caught in the crosshairs. However, I would submit to you that all 3 of our witnesses are professionals. They have extensive education and experience in their respective fields. There are approximately 2,000 students at the school for whom they are responsible not only to educate, but also mentor, prepare for their future, create a safe and productive learning environment, and due to dwindling parental involvement, teach life lessons students normally would learn at home. In addition to this, the teachers at Big Town High School are required to prepare their students for large year-end standardized tests. This is a monumental and time-consuming task. As our witnesses have testified, they do not have time to concoct elaborate schemes that single out one student. Notwithstanding their desire to see their students succeed, with the number of students in the school, it would be counterproductive anyway to single out one student, even if they did have ulterior motives. Thus, the defendant's argument Carson Connors was singled out and a crime fabricated against him does not hold up to scrutiny. Carson testified he did not act violently toward anyone during the events of April 27th, 2019. However, remember, acting violently is not the only form of action that satisfies the charge of disorderly conduct. Threatening or tumultuous behavior will also suffice. And our witnesses testified to those behaviors today, which is why this situation escalated to a criminal matter. Additionally, Carson testified the student he either pushed or patted in the hallway fled the scene immediately after Carson either pushed or patted them on the back and didn't come to Carson's defense when Ms. Smith began reprimanding him. This flight behavior seems to indicate this person did not feel calm, but that Carson did something to make them feel threatened. As I stated, we have met our burden of establishing each of the elements of disorderly conduct beyond a reasonable doubt. We ask when you go back to the jury room to deliberate, you write in the space on the jury form, guilty, finding Carson Connors guilty of the offense of disorderly conduct, helping to put an end to tyrants disrupting the learning environment of our area high schools. Thank you for your attention today and for your service on this jury.
Thank you, Ms. Grover. Ms. Smith, are you prepared for closing?
Yes, Your Honor.
Proceed.
You have now heard both sides of this case, and now you must decide whether or not Carson is guilty beyond a reasonable doubt of the crime of disorderly conduct. Bear in mind, sitting here today, Carson is innocent. It is up to the prosecution to convince you, the jury, that he has met each of the elements required for disorderly conduct. The prosecution has not done this today. They have not met their burden. There are many holes in the prosecution's case, many questions that go unanswered. Where is the student that Carson supposedly bullied? Why is there no other evidence besides Ms. Smith's eyewitness testimony and some missing video footage? Why were there no other students present to witness these events if it was a public place? Why didn't Officer Jones go to the incident when it happened instead of waiting until Ms. Smith got involved? Was this the cue to come and arrest Carson? Why were several other students suspiciously absent during the testing? Why do the studies show that the school to prison pipeline has been implemented at Big Town High? And why does Carson fit the mold perfectly of a student who would be targeted by such a policy? All these questions have gone unanswered by the prosecution. Carson is a good kid and student. He works hard at both his job and he goes to school at the same time. How many of you have had to juggle both work and school? It's not that easy. He tries in school, but there are several subjects where he is in need of more help that he doesn't get from teachers like Miss Smith. Is that any reason to target him with this crime? I think not. We understand Miss Smith was under a lot of pressure to increase her test scores or face devastating consequences. Because of that, she was motivated to make this whole incident up, and with the help of her longtime friend, Officer Jones, she was able to go through with it. She never stated that she felt threatened or fearful, never called for help, and testified that she was not alarmed or annoyed by his behavior. Officer Jones also testified that he had seen incidents like this before, so he also was not alarmed or annoyed or threatened by this behavior. Therefore, any evidence of quote unquote being in a public place as a present element is not met, as there was no annoyance or alarmed or threatened people in the public place in any way. But I ask you, the jury, to not let Miss Smith or this school get away with this crime. Don't let this school to prison pipeline phenomenon progress. Because of these negative motivations are involved, and the elements of the crime here have not been met beyond a reasonable doubt, I ask you to find Carson not guilty. Find him not guilty because he did not commit this crime. Find him not guilty because he was targeted at this school. Find him not guilty because the prosecution has let so many questions go unanswered and have therefore not fulfilled their burden on convincing you, the jury, that Carson is guilty beyond a reasonable doubt of all elements of this crime. I ask you, the jury, to find Carson Connors not guilty today. Thank you for your time.
Thank you, Ms. Smith. Any rebuttal argument?
Yes, Your Honor. Briefly. The defense has brought up to you in their closing argument many quote unquote unanswered questions that the prosecution. However, just remember, these are not elements of the offense of disorderly conduct. The elements of the offense of disorderly conduct are fighting or violent or threatening behavior in a public place with intent to cause inconvenience, annoyance, or alarm. I would submit to you that we have proven here today as the prosecution that number one, Carson pushed a student in the hallway who fled, which is circumstantial evidence that the student felt threatened. Therefore, element number one is satisfied. Number two, the element of public place, we can all agree that a high school is a public place, even if a multitude of people were not present at the time of the incident. Number three, Lauren Smith testified that Carson Connors' belligerent behavior was annoying to her and that he acted with intent, which is element number three. Therefore, the prosecution submits to you that we have satisfied each of the elements of conduct. Carson Connors should be found guilty of this offense.
Thank you, Ms. Grover. At this time, the court will take a recess. When we reconvene, the court will instruct the jury based on the jury instructions that have been approved by both counsel. Court is at recess. Ladies and gentlemen of the jury, it is my duty at this time to instruct you as to the issues of law and the state of the law in the state of Washington. So give me your attention, please. This is in the Superior Court, State of Washington versus Carson Connors, the court's instructions to the jury. Instruction number 1. It is your duty to decide the facts in this case based upon the evidence presented to you during this trial. It is also your duty to accept the law from my instructions, regardless of what you personally believe the law is or what you personally think it should be. You must apply the law from my instructions to the facts that you decide have been proved, and in this way, decide the case. Keep in mind that a charge is only an accusation. The filing of a charge is not evidence that the charge is true. Your decisions as jurors must be made solely upon the evidence presented during these proceedings. The evidence that you are to consider during your deliberations consists of the testimony that you have heard from the witnesses and the stipulation of counsel that was admitted during this trial. If evidence was not admitted or was stricken from the record, then you are not to consider it in reaching your verdict. One of my duties has been to rule on the admissibility of testimony or evidence. Do not be concerned during your deliberations about the reasons for my rulings on that evidence. If I have ruled that any testimony or evidence is inadmissible, or if I have asked you to disregard any testimony, then you must not discuss that testimony during your deliberations or consider it in reaching your verdict. Do not speculate whether the testimony would have favored one party or the other. In order to decide whether any proposition has been proved, you must consider all of the testimony evidence that I have admitted that relates to the proposition. Each party is entitled to the benefit of all of the testimony or evidence, whether or not that party introduced it. You are the sole judges of the credibility of each witness. You are also the sole judges of the value or weight to be given to the testimony of each witness. In considering a witness's testimony, you may consider these things: the opportunity of the witness to observe or know the things he or she testifies about, the ability of the witness to observe accurately, the quality of a witness's memory while testifying, the manner of the witness while testifying, any personal interest that the witness might have in the outcome of the issues, any bias or prejudice that the witness may have shown, the reasonableness of the witness's statements in the context of all of the other evidence, and any other factors that affect your evaluation or belief of a witness or your evaluation of his or her testimony. The lawyer's remarks, statements, and arguments are intended to help you understand the evidence and apply the law. It is important, however, for you to remember that the lawyer's statements are not evidence. The evidence is the testimony. The law is contained in my instructions to you. You must disregard any remark, statement, or argument that is not supported by the evidence or the law in my instructions. You may have heard objections made by the lawyers during trial. Each party has the right to object to questions asked by another lawyer and may have a duty to do so. These objections should not influence you. Do not make any assumptions or draw any conclusions based on a lawyer's objections. Our state constitution prohibits a trial judge from making a comment on the evidence. It would be improper for me to express, by words or conduct, my personal opinion about the value of testimony or other evidence. I have not intentionally done so. If it appeared to you that I have indicated my personal opinion in any way, either during trial or in the giving of these instructions, you must regard this entirely. You have nothing whatever to do with any punishment that may be imposed in case of a violation of the law. You may not consider the fact that punishment may follow conviction, except insofar as it may tend to make you careful. The order of these instructions has no significance as to their relative importance. They are all important. In closing arguments, the lawyers properly discussed specific instructions during your deliberations. You must consider the instructions as a whole. As jurors, you are officers of this court. You must not let your emotions overcome your rational thought processes. You must reach your decision based on the facts proved to you and on the law given to you, not on sympathy, prejudice, or personal preference. To assure that all parties receive a fair trial, you must act impartially with an earnest desire to reach a proper verdict. Instruction number 2. The evidence that has been presented to you may be either direct or circumstantial. The term direct evidence refers to evidence that is given by a witness who has directly perceived something at issue in this case. The term circumstantial evidence refers to evidence from which, based on your common sense and experience, you may reasonably infer something that is at issue in this case. The law does not distinguish between direct and circumstantial evidence in terms of their weight or value in finding the facts in this case. One is not necessarily more or less valuable than the other. Instruction number 3. The defendant has entered a plea of not guilty. That plea puts in issue every element of the crime charged. The state is the plaintiff and has the burden of proving each element of the crime beyond a reasonable doubt. The defendant has no burden of proving that a reasonable doubt exists as to these elements. A defendant is presumed innocent. This presumption continues throughout the entire trial unless during your deliberations you find it has been overcome by the evidence beyond a reasonable doubt. A reasonable doubt is one for which a reason exists and may arise from the evidence or lack of evidence. It is such a doubt as would exist in the mind of a reasonable person after fully, fairly, and carefully considering all of the evidence or lack of evidence. If, from such consideration, you have an abiding belief in the truth of the charge, you are satisfied beyond a reasonable doubt. Instruction number 4. As jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a unanimous verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. During your deliberations, you should not hesitate to re-examine your own views and to change your opinion based upon further review of the evidence and these instructions. You should not, however, surrender your honest belief about the value or significance of evidence solely because of the opinions of your fellow jurors. Nor should you change your mind just for the purpose of reaching a verdict. Instruction number 5. A person commits the crime of disorderly conduct when, with intent to cause public inconvenience, annoyance, or alarm, or recklessly creating a risk thereof, the defendant engages in fighting or in violent, tumultuous, or threatening behavior. Instruction number 6. A person acts with intent or intentionally when acting with the objective or purpose to accomplish a result which constitutes a crime. Instruction number 7. A person is reckless or acts recklessly when he or she knows of and disregards a substantial risk that death or serious physical injury may occur, and this regard is a gross deviation from conduct that a reasonable person would exercise in the same situation. When recklessness is required to establish an element of a crime, the element is also established if a person acts intentionally or knowingly. Instruction number 8. To convict the defendant of the crime of disorderly conduct, each of the following elements of the crime must be proved beyond a reasonable doubt. That on April 27, 2019, the defendant engaged in fighting or in violent, tumultuous, or threatening behavior. That these acts were committed with intent to cause public inconvenience, annoyance, or alarm, or recklessly created a risk thereof. That these acts occurred in Big Town, Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 9. When you begin deliberating, you must first select a presiding juror. The presiding juror's duty is to see that you discuss the issues in this case in an orderly and reasonable manner, that you discuss each issue submitted for your decision fully and fairly, and that each one of you has a chance to be heard on every question before you. During your deliberations, you may discuss any notes that you have taken during the trial if you wish. You have been allowed to take notes to assist you in remembering clearly, not to substitute for your memory or the memories or notes of other jurors. Do not assume, however, that your notes are more or less accurate than your memory. If after carefully reviewing the evidence and instructions, you feel a need to ask the court a legal or procedural question that you have been unable to answer, write the question out simply and clearly. For this purpose, use the form provided in the jury room. In your question, do not state how the jury has voted. The presiding juror should sign and date the question and give it to a bailiff. I will confer with the lawyers to determine what response, if any, can be given. You will be given these instructions and the verdict form. You must fill in the blank provided in the verdict form the words "not guilty" or the word "guilty" according to the decision you reach. Because this is a criminal case, each of you must agree for you to return a verdict. When all of you have so agreed, fill in the verdict form to express your decision. The presiding juror will sign the verdict form and notify the bailiff. The jury has been so instructed, and they will retire to begin their deliberations. Court is at recess.